like to introduce our first speaker. Her name is Rachelle Golden Esquire. She's an attorney and she has extensive experience consulting private and public entities in proactive Americans with the Disabilities Act and Buena Civil Rights Act compliance, which includes transition plan consulting, premises liability, and creating policies and procedures that comply with federal and state laws. She has a successful track record defending clients against lawsuits relating to all aspects of the Americans with Disabilities Act and Buena Civil Rights Act, including website accessibility. She's an active board member with the Fresno County Bar Association, former vice president of the Fresno County Women's Lawyers. She also served as the chairwoman of the Disability Advisory Commission of the City of Fresno. Let's welcome Ms. Golden.
Good morning.
Morning.
And I was telling the staff member over there, that's my ugly water bottle. I should know that. Sorry, everyone. Thank you for that warm introduction. I really appreciate it. So the Americans with Disabilities Act was enacted in 1990. Okay, Bob Dole signed it. George Bush enacted it, and the effective date was January 23 of 1990. Depending upon what the age of your building is, and we're talking about construction-related access claims only. So that means that you would need a ramp if there's stairs. If it's 3 stories, you would need an elevator. If you have consumers come in and have a restroom for the public, it would need to be accessible. And so we're only talking about the places of public accommodation today. We're not talking about your back stock rooms or your employee-only areas. This is truly just the area in which you allow consumers to go, your clients to go. And so what the Americans with Disabilities Act said was, we have completely kind of closeted the disabled population. And so we really, especially after veterans were coming home from the war, Korean War, Vietnam, all of that, we need to do something to make sure that we can infiltrate the American, injured soldiers essentially back into our community. And so the ADA said anybody with a disability must have access to the privileges, advantages, and services of a business. And so in order to do that, you actually need a business that people can come into, like myself, who's in a wheelchair. And so it really was designed to give equal access to those with disabilities. And so it was a really amazing body of law. And it has gotten kind of away from the spirit of it because of California's litigious society. And we'll kind of dive into that in just a minute. Actually, right now. So the Under Civil Rights Act was enacted in 1968. It was modeled after the Civil Rights Act of 1967. And so actually, California has been on the forefront of this way before the federal government caught up, which is actually not abnormal at all. Typically, states will start making change, and then the federal government will be like, oh, maybe we should do something too. So that's essentially what happened with the ADA. And so the UNRU Act is where the statutory penalties come in. I'm sure most of you in the room have heard about these drive-by lawsuits where they're just there to extort money from the business, get a quick and easy settlement, and move on to the neighbor next door. So under the UNRU Act, there's $4,000 per occurrence to the property. So hypothetically speaking, I'm a defense attorney. I don't sue anybody for construction-related access claims. I only do defense work. But just using myself as an example, because I have a disability, if I were to visit, let's say Lorena's business, okay, and I went there maybe 2 times. Well, that's $4,000 per time I visited her business. That doesn't mean that it's $4,000 per violation. So it's not $4,000 for the improper parking slope, plus another $4,000 for the mirror, plus another $4,000 for the incorrect signage. It's per visit, okay? So I want to dispel that myth right out of the gate. And then as was touched on earlier, that also includes attorney's fees and costs. So if that plaintiff can prove that there was a barrier that caused difficulty or embarrassment to them, and they were to win a trial, let's say, they get all of their attorney's fees back. So that $4,000 turns into $150,000 to $200,000 verdict here pretty quick. So that's why most of these cases settle. So that's why we're here, is to educate you on kind of what the top triggers are, so you can kind of go back to your business community and kind of look at your facilities with open eyes. So recent legislation, there's been a lot of work done on the state law level, and I won't go into these ad nauseum because it's pretty complicated, but just know that your state elected officials are working really, really hard to make sure that they can kind of swing that pendulum back into the middle, not to take away rights of those with disabilities, but just to give the businesses a little more protection. And so, yeah, certainly take pictures, whatever you need to do. So those are the names of the bills that have been passed and or have died recently. And I hear often, like, let's just give a 120-day grace period. Let's give a 120-day grace period. Well, the counter argument to that is why should somebody have to wait 120 days in order to access a business when the ADA has been enacted since 1990? It's a pretty significant question. However, in my practice, I find that a lot of the issues that are sued for are not actual barriers, they're just technically not compliant with the California Building Code. And so, I'm not an advocate of taking away I don't think that people should have to wait 120 days, but I think that there should be a heightened burden of proof than there is right now, so that way we can weed out the frivolous claims and really keep in the legitimate ones when there's an actual issue at the facility. So, like I said, take a picture and you can look those up on your own time. So what can you do to protect your business? What you need to do is hire a certified access specialist, and they are licensed engineers, contractors, interior designers. There's one lawyer in town. Hopefully there will be two here in the next year or so. So what they do is you hire them as the business, okay? It's not an undercover situation. It's not like the plaintiff is allowed to send a CAS inspector in without your consent. If you find out that that's been done, you need to report them because that's an unlawful use of the CAS process. And so what they do is they come out to your business and they will give you a list after their inspection telling you every single item that doesn't comply with the Federal Americans with Disabilities Act design standards as well as the California Building Code. Okay? And then once you get that list, it's up to you as the business to decide which barriers are most important to you as far as priority goes. Maybe it's your parking lot, maybe it's your restroom. Okay? It depends upon how many consumers you have that are in wheelchairs versus walkers and canes. You as the business have to decide what your priority list is, and then you come up with a barrier removal plan. When I'm counseling my proactive compliance, I always say do the cheap and easy things first. The trash can, put in electronic lights. Maybe you need an automatic flusher on your toilet. Those are pretty easy things to fix. Let's save the $300,000 bathroom remodel for a rainy day when we can budget and plan for that. So that CASC inspector is really your tool in order to know what your barriers are, so you're given the information that you need in order to make those changes to protect your bottom line and to provide access. Okay? So if you need a CASC inspector, you can go to the Division of State Architects website. You can also email me and I will give you a list of recommended CASC inspectors that I use regularly in Los Angeles. I will say, proceed with caution, you get what you pay for. So there are certainly those CASC inspectors who do a really marvelous job, and there are those that I can look at the photograph and say, where's the notation of 15 other items in the CAS report that's been missed. So make sure if you don't email me for recommendations that you get a sample report from the CAS, and if somebody's not willing you to give that sample report, then move on to somebody else, because it's important that you get to see the work product before you spend $1,500, $2,000, $2,500 on the CAS inspection and not actually get what you pay for. Okay, so please do your homework, but again, email me if you need recommendations. There's also a capital access loan through the state of California where you can borrow up to $50,000 in low interest rate money for CAS inspections and for ADA remediation. Okay, so this is a great resource. If you're a small business and you think that you may need some help, you can certainly utilize that small business capital access loan. There are tax benefits to it as well. And there are certain exclusions, so just keep those in mind, like places of lodging, liquor stores only, not convenience stores, but true liquor stores, places of gambling, obviously escort services and things like that. So if you primarily sell tobacco, you might be excluded. So there are some exclusions, but just for your run-of-the-mill retail business, you should have no problem qualifying for this kind of loan. So I just wanted to make you aware of that, so when we go through these changes and you're like, uh-oh, I'm going to need a new parking lot, the capital access loan might be a really great resource for you and your business. All right, so in this one bathroom, we get to the fun part, and I'm going to rely on Jamie over there to tell me how I'm doing on time. Okay, so in this one bathroom, okay, there's a whole host of violations in this bathroom. You've got paper towel dispensers that are too high and they require twisting, pinching, and grasping. Soap dispensers that are too high and probably too far of a reach range. You've got bars underneath each sink that somebody can't roll into. You've got pipes that potentially have hot water in them that are not wrapped. So in this one bathroom, there's at least 5 violations, and I guarantee you there's a whole bunch more. Okay, so that's why this presentation is here for you, so you can know, okay, well, what do I do in that situation? How do I make this accessible? So we're gonna go through the kind of top 7 triggers that I see in the litigation practice. That's also discussed by the California Commission on Disability Access. The California Commission on Disability Access is a great resource if you just want to kind of Google some YouTube videos and some statistics and things like that, just to kind of get more information. I think it's ccda.ca.gov or something like that, but you can Google California Commission on Disability Access. Okay, so most of the violations that are in the top 7 to 5 are going to be exterior. And the reason why they're going to be exterior is because there's a lot of drive-by lawsuits, and a lot of lawsuits filed based on Google Earth. Okay, so if you run a business and you know that your parking lot is chipped, cracked, your signage is out of date, you've not touched it since you took over the property, and you're like, this doesn't look right, pretty safe bet that it's not right. So, and it's visible from Google Earth. So the plaintiff doesn't even necessarily have to come into your business. They can just Google Earth you and say, I know that I wouldn't be able to access that parking lot, so therefore I'm going to sue them anyway because I was deterred from coming into their business. Perfectly legal. Okay, so how do you fix it? Okay, first of all, most of these are cheap and easy to fix. Okay, one is in signage. Okay, signage is super cheap, super easy, and here's a tow-away sign. And this sign is to let people know who need the space, like myself, the accessible parking. When some Yahoo is parked in that space without a placard, and you tow their car, or I call to get their car towed, they know where to go to get their car when it's towed. Okay, so this black and white sign needs to be at every conspicuous place in every entrance to your parking lot, and it must be filled out. So you need to make sure that the address and telephone number is filled out. Okay, so most people put in the police department, their local police department, but if you contract with the tow company, put their information here, so that way people who are towed know where to go to get their car. And I call when I need a car towed. Okay, so that's number one. Make sure it's in a conspicuous place. If you have the right signage, which this is not, blue and white is no longer acceptable in the California Building Code. If it's behind a fence, you can't see it, it's not compliant. So you've taken yourself from compliance and put yourself into a non-compliant category, and it's a super visible violation. So if I'm doing a street view on Google Earth and I see that your tow-away signage is behind a brick wall, chances are you probably got other violations on the property. So now it's worth my time to maybe even visit that property, or I'm just going to do more investigation on Google Earth and then, make up a date that I visited your property and sue you for $4,000 plus my attorney's fees, plus your attorney's fees, plus your stuff in the design. It's not worth it to wait. Think of this presentation as an insurance program for your business. You're investing your dollars back into your business to increase accessibility, which affects your bottom line, and also to not have to have a rainy day fund for litigation, okay? So the word handicapped is nowhere in the Americans with Disabilities Design Standards, nor is it anywhere in the California Building Code. This word handicap can be very offensive, okay? I don't care what you call me, but there are a lot of people out there who would take great offense to that. And so you'll notice that on the proper signage, there's no disabled, handicapped, nothing. Okay? This is the proper signage that you need for your parking stalls. You can go to stopsignsandmore.com and do not have an vested interest in it and no stake in the game whatsoever, but you can literally buy those signs between $25 and $75. That's a cheap and easy thing to fix. Okay? So start with your signage because it's like a foghorn screaming at somebody who's going to take advantage of your business. So, office parking areas and retail areas, parking is a big problem, especially when you have a ramp going into the access aisle. This used to be acceptable under the California Building Code. And by the way, when I'm talking about the California Building Code, if you comply with that, you have met or exceeded the federal design standards. So if you're going to do remediation, don't rely on the federal design standards because you won't be compliant sometimes with the California Building Code. So always remediate to the strictest standard possible, so that way you are providing the best defense for yourself and also the best accessibility for your consumer, okay? So, and the reason why this is not allowed anymore where the ramp goes into the access aisle is because I park typically with the access aisle on the driver's side. If my door is open and I'm getting out of my car and I put my pressure on this front bar on my wheelchair right here, I've put all the pressure on one wheel and the remaining 3 wheels are spinning out from underneath me because I'm on a ramp, okay? So what should be done is they should take this ramp and put it inside the sidewalk, which is now compliant with California building code, okay? So the signage is incorrect here, and so in that parking lot, there's 2 violations that I can see right out of the gate. I haven't measured it, I haven't sloped it, but I don't need to. I can just look at the photograph and know it's not compliant. Plaintiffs can too. They're pretty well versed in this. Okay, so while it looks relatively up to date, it's not. It's definitely not. So this is what a parking space should look like. Okay, it's got the correct signage, it's got the wheel stops to prohibit the car from going into the path of travel. Okay, it's got your ISA symbol right here, which is the international symbol of accessibility in blue and white. You can't see it, but there's no parking right here on this access aisle. And it provides a clear path of travel to the front entrance. That's what your parking lot should look like. Not talking about every single space, I'm just talking about your accessible stalls. So 1 in 25 stalls need to be accessible, and it goes up from there. So if you're, 26 to 50, then you need 2 accessible stalls, and they can share that access aisle. Your CASC inspector will know based on how many spots that you have in your parking lot, how many accessible stalls you're going to need. Okay, so this only applies to the accessible areas. This does not apply to the remainder of the parking lot. So let me make that clear. Maintenance. Maintenance is presumptively, faded paint is presumptively not discriminatory. However, if it's faded to the point where somebody can't tell where the accessible stall starts and stops, or where the access aisle starts and stops, then it's not usable in an accessible way. Because somebody may be parking in that spot who doesn't understand or doesn't see that it's an accessible spot, taking away the opportunity for the person who actually needs that spot. Okay, so maintenance is relatively inexpensive. It's relatively inexpensive to stripe your parking lot once a year, once every 2 years, depending upon your budget and your barrier removal plan. Okay, so once you become accessible, that doesn't mean your hands off. You still need to maintain those accessible features. Access routes, they had a really good intention with this access route. It looks super great, it's bright blue paint, you've got the curb stops, except they placed a pole right in the middle of the path of travel. You'd be surprised how many times I see this, especially with planters on a raised path of travel. So you park, you get out, and you're going down this path of travel, and there's flower pots on both sides. Well, now you just impinged upon my clear floor space to get to that front entrance. Okay, I have a small wheelchair. I can go pretty much anywhere, but there are a lot of people out there who use power chairs or scooters. They can't navigate that because they need more space. They need the full 36 or 38 or 42 width, whatever the configuration of the parking lot inside the store is. So make sure that you keep all interior and exterior paths of travel free from obstruction. Okay. This is a really great winery, and they have cobblestone. Okay, you can't have an uplift more than 1/4 of an inch. It's not a flat surface. I guarantee you there's portions of this stone that exceed 5% running slope and 2% grass slope. Okay, so you don't need to rip out your cobblestone. You just need to provide an alternative access route with appropriate signage directing the person where they need to go in order to access that facility in a way that's accessible. Okay, so just because you have one doesn't mean that's the only one you have to have. You can make accommodation and provide equivalent facilitation just with a different route. It's perfectly acceptable. That's barrier removal. Okay, so your CASC inspector will be able to work with you to say, hey, well, where do I put this? Okay, well, you need a ramp and you need a path of travel in the parking lot. Let's brainstorm about this. So make sure you do your homework and make sure that your CASC inspector is on board with providing those recommendations for you if that's what you desire. So this is an accessible route to the back of a business. This was in an old town area. So while this ramp is disgustingly steep, first of all, it's very, very, very steep. I would be surprised if I could push myself up it. But they've also created a whole bunch of obstructions along the way. So if you are going to provide an alternative route, make sure that it's actually accessible. Okay, don't take it. Let's say this ramp was compliant with 8.33%. It's not, but let's just say it's probably 15% slope, maybe. Let's say they blocked it off. Okay, so again, keep your access aisles clear. If you do have an alternative route, this is the signage that you need to have. Again, stop sign is more. I think they're like $25. It's not that expensive. Okay. Doors and entryways. People with upper mobility dexterity problems a lot of times cannot use their hands. Okay, so like a lot of quadriplegic victims, they run their electric wheelchairs with a joystick. Okay, some of them have the strength to open a door, some of them don't. But the ones that do, they need to open it with their fist because they can't pinch, twist, or grasp. If you have a doorknob, they have to pinch and twist it. Okay, so they can't do it. So you've taken this door and made it inaccessible. So make sure you do it on both sides of the door. This isn't going into a restroom. They put a lever on the outside of the door, but then put a knob on the inside of the door. So while the person could go in and use the restroom, they couldn't get back out. Okay? Seems common sense, but obviously it's not, because this is an actual condition that's been seen in the field. I didn't take this photograph, but I talked to the person who did, and it's not a Google image, that's a legit image. So this is what you need. You need doorknobs that you can not pinch, twist, or grasp, pushing open, using your fist, pulling a door open. Okay, so if you go back to your businesses and you can't open your door with your fist, you are not in compliance. So these doors are perfect for push, right? Back there's levers. You can open those with your fist, okay? Door pressure, this also goes to maintenance. I see a lot of complaints that say the front door is too heavy. Well, you need 5 pounds of push or pull pressure. So this little gizmo right here will tell you how heavy your door is. You can get those online on Amazon, you can get them at Home Depot. And some of them have hooks on them, so where you can hook on and pull the door open, it'll measure. There's also swing requirements that are included in that, so your CASC inspector will check your doors. A lot of times, all you need to do is just adjust the closer on your front door, okay? So if you don't have a closer on your front door, maybe you need to get one so it doesn't slam shut so quickly. Okay, again, those are not that expensive. You can call a local door company, which would be more expensive, but if you need to retrofit your front entrance, you need to retrofit your front entrance. Because somebody that can't access your business, first of all, isn't going to buy from you. And second of all, they're not going to come back. They're going to tell their friends not to come back. And you're probably going to wind up with a lawsuit. So not only have you lost money in revenue, you've also lost money because of the lawsuit. So, fix your doors. All right, the ISA symbol, the International Symbol of Accessibility, goes on every accessible entrance to your facility. If you only have one entrance, that's accessible. Arguably, you don't need that sign. However, it's such an easy thing that I would always recommend putting up the ISA symbol. And the reason is because the code used to require this on every accessible entrance, even if there was only one. Senator Roth created a bill in 2016 that said we're going to presume that not having this on the only entrance is no longer a barrier to accessibility. However, I have seen people be sued for it, so now you've got to litigate that. It's not worth it. Buy the $12 sticker and stick it on your front door. Okay. So this is exactly what it should look like. That's relatively the appropriate height. Your CASC inspector will know where they go and how high they should be posted. I'm blowing for these guys, I'm sorry. Inside your facility, again, keep your clear floor space clear. So if this is from this shelf to this shelf, 44 inches, and this narrows it down to, let's say, 36 or 32 inches, you've taken yourself out of compliance because you're serving both sides of the aisle and you need 44 inches of clear floor space. Okay, so you don't have to remove these from the store, you just need to put them in a different location so they're not impinging upon the clear floor space as in the circulation path. Okay, and if you're only serving one side of the aisle or if you're doing a U-turn over an aisle, there's a whole bunch of different configurations and different measurements that are involved. Again, your CASC inspector will know what those measurements should be, and a lot of times it's just a matter of rearranging shelves. Okay, most of the time you don't have to remove a shelf. You can get creative and rearrange and provide access without losing any retail space. Okay. All right, signage. All exit signage needs to have braille for those with visual impairments. And so also elevators, if you have a building with an elevator in it, make sure that each floor and each button also has braille. If you have questions about whether let's say you have a pretty significant blind population that comes to your business, or even one regular consumer that comes to your business, and you have questions about whether your braille is accurate or not, your CASC inspector probably wouldn't know that. Sometimes they do, most of the times they don't. So So maybe there's some more research that needs to be done to have somebody actually come out and read your braille signs. But most often people are sued for construction-related access claims, not communication barriers inside of a business. So just be aware of that though. Each exit sign needs to have braille. Service counters at grocery stores can be 38 inches high, as long as there's a check writing station that's 34 inches high. However, see there's the check writing station. If this is a transaction counter where you're doing things other than checking people out, maybe you're doing some gift wrapping, maybe you're doing balloons behind the counter, maybe you're picking out flowers or whatever this may be, getting clothing from behind the store or behind the counter, what have you, it needs to be 34 inches high the whole way for 36 inches. So depending upon what facility you have is going to depend upon what your counter height requirements are. Okay, so your CACCOC inspector will know what that is, but it's pretty safe to say it should be 34 inches, 36 inches wide. Okay, that's, if you've done that, even if you are like a small grocery store, liquor store, what have you, you've exceeded your requirements under the California building code, so you'll be in good shape. I always try to be a little bit more conservative than the code maximums, just to give you guys a little bit of breathing room. This is a counter space that is accessible, but they have jumped it up. Okay, there's a case out there that came out. There was some debate about this last week. It does say that we're going to presume that this having it jumped up is not a barrier to accessibility anymore. However, that's something you're going to have to litigate if you do. A store that's more than 10,000 square feet. I think that's the measurement. Lorena can tell you that. She's a CACCOC when she's in the room. I may have gotten the number wrong. Then you may not need to have a restroom if you're an existing facility. If you're a new facility, different ballgame. Okay, if you're doing brand new construction, different ballgame. But if you're an existing facility, totally different standards. Don't make it available. It's not worth it. So this is what, and the reason why I have this picture up here is because there's 4 stalls, not one of them is accessible. So if you have one stall only, it needs to be accessible. And there's ratios that go up from there. So if you have 2 or 3 stalls, maybe you need an ambulatory stall. If you have 5 or 10 stalls, maybe you need another accessible stall. So depending upon how many restrooms you have in your business, is going to determine how many accessible stalls you need. There's none in this picture. Okay, just the door widths alone are a problem. Okay, because if I'm going to use that restroom, thankfully I can transfer to the toilet, but sometimes it's too far and I have to get on the floor, gross, and get myself back up. Okay, so it's not worth it. Just convert one of the or 2 of these stalls into an accessible stall. I see people do that all the time. It's just reconfiguring partitions. Okay. This is what an accessible restroom looks like. You've got grab bars behind and on the side. The toilet paper dispenser is next to the toilet, 7 to 9 inches from the front of the toilet. You've got your flush handle on the outside. So this is a good example of what a standard restroom should look like. If your grab bars are too long or too short, or your flush gauge is on the wrong side, or if your toilet paper dispenser is up here, you're not compliant. And a lot of times these are just slapped on by vendors. The owner has nothing to do with that. So work with your vendors to make sure that when they are placing those dispensers, that they place them in the right spot. Like this one is not correct. Okay, it's too high. All right, so this one bathroom has a boatload of violations in it, a ton. So sink wrapping I see all the time. The reason why this is an important barrier to address is because if you have hot water in your sink, and I am a person with a disability that can't feel temperature sensation in my legs, and I roll under the sink and the hot water is running, that pipe gets hot. I'll burn myself. Okay? So it's not expensive to wrap your pipes. Some people get an insulated bag, some people wrap them with some sort of foam covering. Just wrap them so that way you're protecting those from getting burned. And recap. Okay, so be proactive and get a CACCOC inspection. Make sure that you train your employees. If you see somebody struggling, don't wait for them to ask. Please, for the love of God. Okay, not everybody's out to sue you. There are those that actually really want to access your business and may need help. So a little help goes a long way. So train your employees. If you receive a complaint or a demand letter, do not ignore it. Hire an attorney right away. Same with CACCOC inspectors. Make sure you do your homework on the attorneys that you hire, because not everybody is even aware of some of these nuances of the law and whether it's a federal requirement or whether it's a state requirement or how they can defend against these cases. So make sure you do your homework as well. And then if you need help, get the KACCOC loan, or at least apply for it or look into it. If you do make accessibility modifications, let your accountant know, because there are tax deductions and credits that are available to you, that your accountant should be aware of. So as some of you may understand, or may have learned about, a lot of people are getting sued for their websites these days, having an inaccessible website. So I'm just going to briefly go through, those are some stats right there as to the targeted industries. So it's retail establishment, food service establishments, places of lodging, banking, and entertainment and leisure. From 2017 to 2018, the percentage of increase in website lawsuits jumped to 177%. I said 177% improvement rate. Okay. This year they're expecting another 19% increase between 2018 and 2019. A lot of times the plaintiffs don't even live in the state of California. A lot of times they live in Arizona and Florida and New York. So they're suing California businesses for places that they've never been, nor will they ever go to. They don't know why somebody in Florida needs to have a gift card from, Joe's Steak Shop at 2 o'clock in the morning. But if they can't do it and somebody else can, then it's a barrier. Okay? So a website is a place of public accommodation if there's a nexus to your brick and mortar. So if you're only an online business at this point in time in the state of California, there's no law that says you need to have an accessible website. However, if you have a physical location, let's say you have a retail shop and somebody can order online jeans or whatever, now you've got your internet, your website has a direct nexus to the brick and mortar, and so it needs to be accessible. So what does that mean? The website needs to be perceivable. Okay, WCAG 2.0 AA is really great for desktop websites, people who use their desktops to access your websites. 2.1 just came out last year, and if you have a heavy mobile device audience that accesses your website through mobile devices, which most businesses do these days, then 2.1 is going to be a better fit for you, because that's actually geared more towards mobile devices. So, the website or the mobile app has to be perceivable, which means that somebody with a hearing, visual, or cognitive impairment must be able to perceive and understand the content on your webpage. Okay? So if you've got videos, it needs to have closed captioning. Maybe if you're doing a live stream, it needs to have closed captioning. If you have a lot of pictures on your website showing the products, you need to have that coded with alternative text that says jeans, women's jeans, or male shirt, red shirt, polo shirt, whatever it may be. Child running in the park if you're some sort of recreational business. So make sure that your web developers understand and appreciate what this actually means. If you talk to your web developer because you want to know if you're compliant or not, and they don't know what you're talking about, chances are you're probably not compliant. Okay. So operable means that people, again, with a limited mobility dexterity, they a lot of times can't use a mouse. So they need to be able to navigate the website through the keyboard. If you're coded to 2.0 AA or 2.1, your website would allow that person to do that. Okay? Understandable, again, has to be understandable, meaning somebody who has a visual impairment who cannot see what's on your website needs to have that coded so that their screen reading software can read the screen aloud to them so they can access the website just like a sighted person can. Okay? And then robust. If you're coded to be WCAG 2.0 AA or 2.1, it will be robust enough to keep up with the new assistive technologies that are coming out in the market. So there's technologies that I'm not even aware of, but if it's coded correctly, it should be compatible with those assistive technologies. Okay? And again, it's $4,000 per occurrence, so it's $4,000 per visit. So somebody could say they went 12 times to a website pretty easy. Okay? Some jurisdictions will cap it at 3 visits, some jurisdictions won't. It just depends on where you live. So, what can you do? You need to, oh, it's not up here. I truncated it too much. You need to get an audit done. So there's a lot of automated tools out there on the internet. It's a great starting point. Download them. They'll read your website. They'll tell you what's wrong. But the caveat is if you do it more than one time, which you should, you will probably get different results. Okay? The best and kind of the ideal way to do an audit is a live user audit from a company who actually has people on staff with auditory, visual, or cognitive impairments that will actually use your website with their assistive technology. It's expensive, okay? So you may need to put that into a barrier removal plan and rely on an automated test right now and just fix the things that you can, and then kind of gear up just like you would for your construction-related access claims to save for that live user audit and completely revamping your website. If you use a template, WordPress, Squarespace, GoDaddy, some of them do have WCAG 2.0 templates, most of them do not. And the minute you start uploading your own content to it, you have taken it out of compliance. Because the stuff you upload is not coded to do that. And if you use a template website, a lot of times they're secure in a way that your web developer cannot go in and recode them. I know GoDaddy for sure does that, and they have no WCAG templates last time I checked. So it's very important you work with your web developer. If you need an audit company, again, email me. I work with some throughout the entire country. There's some that are local here in Los Angeles that do a really great job. So I have those resources for you if you need them. So we talked about the nexus to the brick and mortar. If you are anticipating that there's going to be some accessibility barriers on your website, put up an accessibility statement that says we are committed to providing access. If you're having problems navigating this website, please contact our web developer at such and such email or telephone number. Please contact us and we'll assist you in any way that we can. So that shows that while there may be a barrier, you're still actively trying to work with that consumer to make sure that they have the same access as those who are sighted and who have their hearing and are cognitively unimpaired. Okay, you're still providing access in an equivalent way, equivalent facilitation. So that was it in a very short nutshell. So this is a great resource, the California Commission on Disability Access. Like I mentioned earlier, the Department of General Services is where you can find CASC inspectors, and then the CalCap one. These are here for you, and thank you very much.
One question, I'm going to ask one general question. We won't take specific questions due to time, but there's one question that I always get as a practicing lawyer myself is, who's liable? So if you're renting a space as a business, is landlord liable, tenant, both? You want to explain?
Okay, so you're both liable. So if you are a tenant and you have a new or renewed lease from 2017 or newer, your landlord must disclose whether a CASC inspection has been done to your property or not. They don't have to have a CASC inspection done, but if they have, then they have to disclose it. If the lease is silent, then it's presumptively the landlord's responsibility for all barriers, interior and exterior. Okay, so it's a lease question for new leases. Leases that have been executed before 2017 will be a joint and several liability, and then you, landlord and tenant, have to fight behind the scenes as to whether or not what the scope of control is and what the leased premises are. But the plaintiff is not a party to those contracts, whether it's been disclosed or not. And so in either situation, they're jointly and severally liable to the plaintiff, and then you guys have to figure it out on the back end. What I typically do is if I'm doing a motion to dismiss because my client has fixed everything, which happens quite often because the complaints are pretty skinny in what they allege, I'll have my client fix everything, and then I'll do a motion for declaratory relief to have the court look at the lease to say, all right, tenant, you're out. But I have to file a separate motion for that. Okay? But to the plaintiff themselves, you are both jointly and severally liable.
Thank you so much. We'll take specific questions after the presentation. Let's give a round of applause.